Mr. Superintendent.
Yes, at this time, I would like to welcome everybody to our workshops for today. Our first workshop is about the expulsion process at the request of the board. And at this time, I will turn it over to the team. Mr. Oswald, I will let you introduce all the people presenting today.
And good afternoon. Thank you all. We're excited to be able to talk about expulsions. I know this has been long overdue. We have our Chief Academic Officer, Dr. Sheffield, our Assistant Superintendent of Student Wellness, Junisa, and our Attorney, Lisa Carmona. At this time, I'll go ahead and turn it over to Dr. Sheffield.
Good afternoon again, Board. At the request of the Board, we're excited for this workshop for you today regarding our current state and our desired state for the expulsion discipline process. Point of discussion will be around zero tolerance and the mitigation factors. The first part of this presentation, we will be outlining our current process, and the last part will be suggested recommendation with the suggested timeline per board approval. At this time, what I'm going to do, I'm going to turn it over to June Issa, that's going to assist us through the first part, and then Lisa Cremona, our outstanding attorney that works with us very heavily in the area of academics, will be assisting June as we go through the current state. And once again, we will lead from the current state with recommendations from the board per approval for desired state, with an understanding that we would like to come back before you to talk about the desired state. June.
Good afternoon, everyone. The definition of what an expulsion is up on the screen, and it is the removal of a student from one of our comprehensive public schools. Here in Palm Beach County, we do expulsions with educational services, and we also expel our students for no more than 1 year. So that is the definition of expulsion. That's what we're going to be talking about. The current expulsion process I'm going to outline for you. I'm going to give you the highlights of what we presently do within our expulsion, all of the steps that we take before we actually bring a case to the school board. And then I'm going to talk with you a little bit about, as Dr. Sheffield mentioned, about what our desired state is and what we're going to be looking for. So the first thing that we do once a child has had some type of infraction on a school is that the school center does a thorough investigation. If necessary, they would notify their SRO or their LEO if there's weapons involved or drugs, drug paraphernalia, assault, batteries, etc. Those would all be notifications to the SRO or the LEO. From that point, once a school has made the determination that it is an expulsion that they'd like to move forward, they would call their regional or their instructional superintendent to ask for approval. And in that conversation, they would have talk about the fact, what type of student, where the student, did, et cetera, and then they would make a determination as to whether they might want to do an alternative setting for that child or move forward with an expulsion based on the circumstances. After that, the next step is that they would go to the director of safe schools and they would discuss again the situation that took place, and we would verify that the actual offense is an expellable offense based on our student code of conduct. Once all of those permissions have been given, the school center then puts together a packet that is submitted to the Office of General Counsel. Other copies are sent to the instructional regional superintendents, as well as the director of safe school. If the students had any kind of incidences over the school year that would have warranted them being talked about through the school-based team, all of that information would be included in the packet. Mail notification is sent out to the parent on the school letterhead. They schedule a conference to bring that parent in to have those conversations. After all of that has taken place, we have what's called a principal screening committee. It's made up of 2 principals at each one of the levels, elementary, middle school, and high school, as well as regional representation. We go through each one of those cases, and a decision is made on each one of those situations as to whether we're going to be moving the expulsion forward. Once that has taken place and we have made the determination through the committee that they are going to move the expulsion forward, at that point it is brought to the chief academic officer or the deputy of schools. So that is our present expulsion process. I'm going to have Lisa talk a little bit about the legal sufficiency checklist for when they get the packets in their office.
So good afternoon. Every expulsion packet that is presented to the Office of General Counsel is thoroughly reviewed for legal compliance. We've developed a comprehensive checklist of items that we look for to ensure that all aspects of the expulsion have been done in compliance with both state law, federal law, as well as board policy. This includes looking at the notice. We make sure that it's coded properly, that the offense is adequately described, that it has been signed and dated, mailed as required by law, and translated if needed as well. After that, we'll look for compliance with board policy and procedures. This is Board Policy 5.1817. Make sure that, again, that the expulsion packet has been reviewed by the regional office, by Safe Schools, and that includes all the items that are required in the packet per board policy. If the student is under a 504 plan, we'll also make sure that notice was provided to the parents, that they have a right to request, and that a manifestation determination has been conducted as soon prior to the recommendation for expulsion. The last piece we look at is the evidence. We will look at the packet to make sure that the packet contains witness statements, photographs, and other items that would help us support or substantiate the principal's recommendation for expulsion. That being said, when we look at all of these items, we then will go back to the schools and communicate with them in order to assist them with correcting any legal deficiencies that might be there.
So as Dr. Sheffield mentioned, we are going to talk a little bit about the desired state. It's been a request that we look at our expulsion process, and through that request, we have researched other large urban districts here in the state of Florida, and we have identified some areas where we believe that we can make some changes and improve our process. So there are big bucket items on this first slide, and then I'm going to go into the details of each one of them. The first one is to improve communication with parents regarding the process. We will, as a system, create a video explaining the expulsion process in terms that are easily understood and also will be translated for our parents and guardians. The second bucket will be the opportunity to increase the parental input and involvement. And that's going to take place at a number of different steps, and I'll go over this as I move forward. But one would be in what we're going to now call the expulsion committee meeting, which would be an informal opportunity for the parent and the student to meet with a committee. The second will be hearing officers, which will be an impartial individual that will hear the cases. And then the third would be a formal meeting here in front of you in the board. The Expulsion Discipline Committee, and again, I'm going to break this out a little bit further, but it's going to be a new process for parents and students to meet with a committee to discuss the incident. So we'll be with a committee of individuals from the school center, the district center, the regional office, et cetera, for the parent and the student to express what their side of the situation was as the incident took place. So the first bucket is to improve communication. As I mentioned, we will be creating a video that details the expulsion process, what parents can expect, who they can contact, all of the contact information. And we're going to make sure that video link is placed in numerous places so that the parents can find it. It'll be posted on the district website. Any mailings that take place to the parent, it would be included. And in addition to that, once the parent does go over to the alternative ed site, while this process is still taking place, we would make sure they see the link at that time as well. The second one is the parental input and involvement at all stages. So we wanted to look at making opportunities for the parent and the student to be able to discuss the situation with different groups. The first one, as I mentioned, would be called the Expulsion Discipline Committee, and that's where the staff from the central office and the school center and regional offices, et cetera, would sit down with the parent and talk about the incident. The school would discuss what happened on their side, and the parent and the student would have an opportunity on their side as well. The hearing officer is going to be a new piece that we would be adding, and the parent and student participate in an impartial hearing pursuant to the Florida statute that's listed. And those hearing officers are going to be hired by the school district. So we would have consistency with our hearing officers. And then the third part would be the school board opportunity for the parent to be heard here, where they have the opportunity to address the board. It would be here in the boardroom before a formal meeting has started. The last one, just a little bit more about the Expulsion Discipline Committee. Again, I've referenced what it would be, what the opportunity was, but that's the opportunity for us to talk about considerations that the committee can make. For example, if it's a graduating senior and it's March, do we want to talk about another opportunity rather than moving that child forward for expulsion? You know, what's their discipline history? What's their community support? But all of that conversation would take place at the school center with the parent and the individuals that I mentioned. So this is the key changes. It goes through all of the different steps of what I just described, inclusive of, you know, the hearing officers down at the bottom. If you look at that one, it says hearings are conducted at district office or regional office on set days. So we would have a calendar where the hearing officers would hear the cases, and they would be set locations. So we would have them throughout the district, and we would have them on set days so that we can keep the basically the docket and the conversations going. After the hearing officer issues their findings, that information would be shared with the board. So the board would have all of that information prior to the parent if they chose to come and speak with you at a board meeting.
So a big part of our expulsions pertains to zero tolerance and the application of the zero tolerance statutes in the state of Florida. Florida has a very specific zero tolerance statute which requires students who have brought a firearm or weapon to school or made a threat or false report involving a school or school personnel or property to be recommended for expulsion for a period of not less than 1 full year. If you want to move forward. Yeah, thanks. Expellable incidents include the poster transmit a threat of mass shooting, a bomb threat, an imminent threat of violence, high level, possession of a firearm, handgun, rifle, shotgun, possession or use of an explosive device, possession of a knife or other potentially dangerous items, armed robbery, sexual battery, kidnapping, or homicide are all specifically included in the statute. The statute also allows the school district to include in that other items that are a threat to school safety, and as such, the district has added sale or intent to sell or distribution of drugs to that category. The statute defines weapons specifically. We rely on 790 of Florida Criminal Code, which states that a firearm includes a weapon and parts of a gun, such as the frame or receiver, the muffler, or any part of a destructive device that is part of a gun. This is something that has come up in the past, so we thought we'd bring that to your attention. The weapons definition is also very specific as to what constitutes a weapon. We've got a list of weapons there that excludes pocket knives, plastic knives, or blunt-bladed knives, such as butter knives. That is to avoid the common defense that we hear about sometimes in the media about in other districts we've heard of young children bringing in a butter knife with their peanut butter and jelly sandwich. The last category we have under weapons is the electric weapon device. This includes our tasers. These are specifically categorized as weapons under Florida Statute 790. These definitions are also covered by our Code of Conduct. They've been there for a while. Dangerous items include any instrument or object that can place a person in reasonable fear of serious harm. This would include, for example, students who bring a BB gun or airsoft gun to school, have taken off all the safety tips, it looks like a real gun, and that item is then held to another student and used as a threat. Firearm and shotgun, I think we all know. The last portion of the zero tolerance statute requires, or specifically, I should say, vests authority to mitigate in these cases only to the superintendent. In this case, the statute specifically states that only the superintendent may consider the 1-year expulsion requirement on a case-by-case basis and request the district school board modify the requirement by assigning the student to a disciplinary program or second chance school if the request for modification is made in writing and it is determined to be in the best interest of the student and the school system.
So at this time, we have laid out what we would like for the desired state to look like, and we know we have some work to do to get to that point. So what you have in front of you now is the proposed timeline. It shows in August we'd like to review suggestions from the school board, garner input from our principals, and determine the committee and staff needs that would be necessary for us to move this forward. September, we would bring back another workshop reviewing a new policy and the procedures. October, do the development of that. And hopefully by November, we would be able to do adoption of that policy. And then at that time, move forward to hiring our hearing officers and then working on the training piece that we would need for school centers and staff to be able to implement the new process. And then hopefully we would be able to be in place for the second semester and move this forward at that time. Thank you.
Mrs. Whitfield, and then Mrs. At the end.
The other one. Thank you guys so much. I know this was a ton of work for you to put this together, and I really want to thank you for putting so much time into it. Just two clarifications, and then I want to talk about a question. The first thing I wanted to mention was the video link idea. I love it. I think it's so great in native languages. People can be explaining it to them. That's how I learn best, is by talking to people. I know other people feel that way too. So I think that's such a great idea. The questions I had on the PowerPoint, under the slide where you just had weapons and then you wrote firearm, weapon, and electric weapon or device. In the weapons section, you wrote means any dirk, knife, metallic knuckles, slingshot. I think that's supposed to be slingshot. Billy, it's a slung?
It's a slingshot.
I don't apparently have enough weapons in my life. Billy, tear gas, gun, chemical weapon, or device, or other deadly weapon, except a firearm. So do you mean antique firearm there?
No, the firearm has a different classification above as firearm.
So that, okay.
Yes, that's the
There's
way
like
the statute
there's a type
defines.
of firearm that doesn't count as a weapon.
So there's a firearm, there's a general definition of weapons. There's a firearm under the criminal code that has a specific classification as a firearm, and the items that are there are classified as firearms. But then weapon is defined separately in the criminal statute.
And then the common pocket knife, or really anything in the world, if it was used as a weapon, then it's considered to be a weapon?
Yes.
So if I took like a
it's
lamp,
used to place another person in
somebody?
reasonable fear for their safety.
and then does that count as a weapon in our world of expulsions, zero tolerance of expulsions, if anything was used as a weapon?
Under our student code of conduct, if it's used to threaten another student or someone else and there's a reasonable fear, then yes.
Okay, so under the zero tolerance thing, it occurs to me that all of those things could be things that make you end up in jail. So is there and I think this is true, but is there a place where somebody could have not ended up in jail, but they do end up being expelled, right?
Yes, in fact, I mean, we've got to keep in mind that our criminal statutes and our education code are two separate laws. These two sets of laws kind of intertwine, but they don't. So our education code is relying on some definitions from the criminal statutes, but at the same time, that is not really, we don't rely on whether or not the state attorney decided to prosecute, whether the student was adjudicated. Once the offense occurs, we take charge of it based on the student code of conduct and our law and our applicable education code laws. We do not really look at what happens on the criminal side of the house.
So we'll just do it in our own little world, and then they can do their part in their world. If they find out in the criminal world that they were not guilty or it wasn't proven, does that have any impact on whether or not we would expel them? There's no coming back?
We would have reviewed the case to ensure that we had the evidence we needed.
But our evidence level is lower.
Yes.
Okay, so when we, you have the part about the superintendent may consider the 1-year expulsion requirement on a case-by-case basis. We have no impact on that. It's only at the superintendent's discretion, not the school board, right? Okay,
Yes.
just double checking. Okay, so I know we're going to talk alt ed in a second, but I think one of the things that I really want to just make a comment like publicly about my thoughts on this is obviously through this process, expulsions become really important because we're in such a security conscious world and we are so worried about who's on our campuses. So we are going to have to continue to expel children, which I hate, but we have to. My worry really comes down to, and I've mentioned this to a lot of you before, is that we lose those children, right? So that when we get to those kids, we are not finding a way to bring them back from whatever horrible thing that they did. And if they're not in jail and they're still with us, then to me, that's our responsibility. And I think if we don't find a way to still make them whole again, or try to make them whole again, I think our communities are going to be forever impacted. So that's what makes me so uncomfortable about expelling children, is I know they have a better chance within our regular system than they would in a system of our alternative ed. So when we're talking alternative ed, I think this all makes perfect sense, and it's so much clearer to me now how we have to expel children. But as we're moving forward, I think our alternative ed has to be really robust and beautiful and be a place where we feel like kids are actually have a shot. And as long as we can do that, then the expulsions won't be so painful. Thanks.
Mrs. McQuinn?
Thank you. Again, thanks to all of you for your hard work with this. Just a few questions. In particular, Attorney Lisa Carmona, thank you for your organization and efficiency when we met, and listening to me in terms of the, looking at this, the committee, the Expulsion Discipline Committee, in terms of having consistency across the district. So thank you for that word being in there. I appreciate that. Also the video, very excited about that. Couple of questions. One suggestion too, let's go back to the committee. Just a suggestion. Sometimes we find that we tap the same principles over and over for things. So suggestion that your principal divisions, elementary, middle, and senior, and other, that they have some suggestion, that they have some input into what principal is representing them when they come for that discussion. And it doesn't mean on the actual committee. I'm sorry, I was confused. I wasn't confused about that. I wasn't clear about it in determining how the policy moves forward. That I'm not the committee. I mean, you do what you have to do with that. But in terms of the policy input, some principals heard that the board does not want to expel. I don't know of one educator who wants to expel. But as Ms. Whitfield said, we have to expel. So it's not that we won't. It's just no one likes it. So I want to clarify that. So my only other question, actually two, but if I read correctly, then it's the superintendent, before he brings a recommendation before us, who can consider mitigating factors. Did I miss those mitigating factors in here? Do we know what those mitigating factors are?
Yes, those mitigating factors would be the same mitigating factors that were listed earlier in this presentation.
I thought I just missed them.
Yes.
I couldn't find them because I was listening. Okay, I'm good about that. Okay, so the hard question is, then, what is the role of the school board?
So, again, this is, our very artfully drawn statutes.
I'm sorry, I'm really sorry to have to break in here, but it's for the zero tolerance cases where the superintendent has the discretion for the mitigation.
Yes.
Okay, so I just want to make sure that that's clear when.
Thank you.
Okay. Oh.
I'm really, and you know the question I'm asking.
Yes.
For example, I have researched in terms of personnel recommendations, the role of the school board.
Yes.
So now,
In terms, so there are two sets of expulsions, right? So there would be the zero tolerance expulsions that are required by state law. In those cases, the superintendent would have the authority to mitigate, and he is the person who could then make a recommendation to the school board that that student be placed in alternative ed in lieu of an expulsion. The other cases would still allow for mitigation by the school board, non-zero tolerance cases.
thanks.
Mrs. Andrews, and then Ms. Brew.
Thank you, and to the team, especially Ms. Kimona, this is fabulous. It was wonderful to sit down and give my input, and I see it's in here, so I think we're on the road for making sure our children get as many opportunities to have their voice heard as it relates to what they're being accused of. And so I think all of these layers are very, very good. And I like the idea that they're going to be able to go to the site, the campus, the alternative site. The parents will be able to sit there, look at it, go and visit the classes or whatever, look at the video to make a determination as to whether that could be a fit for their particular child. So I like that, but I loved all of this because I think we're right now on track. And as you said to me, that in other districts, they're there. So now they're there getting to this level to make sure we have more opportunities. And the other piece I wanted to ask was about the committee. What kinds of people will be sitting on the committee?
Maybe Ms. Issa could.
Well, to start with the committee, of course, we definitely would like to have our principals' input, and we would work through the divisional leaders to decide in regards to who would be the representation from the various level, because we do realize that we would need to make certain that the principals that are assisting us is representation of our entire student group. So most importantly, our principals, and we will also be looking as it pertains from our alternative sites, to have representations from our alternative sites as well, because we do provide services to students if they are expelled or being considered, that those students will be placed still in alternative sites. So it would be important to have representation from this site as well. And we are building the committee as we're going on, Mrs. Andrews, but that's where we are starting. Those were the two most important subgroups to us at this moment in time.
Would there be a consideration for someone that may not be a part of the school district?
We're definitely open to those considerations. We could follow up with you.
Ms. Bro?
Thank you, and I too want to thank you, and I also want to thank Ms. Cremona for walking me through the changes. And before I ask my question, the one thing that jumped out when I spoke to Ms. Cremona, and I'm sharing this because of the comments that Ms. Whitfield made, is that we do offer educational services to our students that are expelled. And I think that my understanding is that that's unique. Not every district does that. And so I think that's something that we should be very proud of. Yes, we could be doing some of the counseling better. I mean, there's always room for improvement everywhere, but I think that's something that we really need to tout, because we do not leave these children without them getting an education. So I think that's great. What jumped out at me with this presentation on page 11, when Ms. Issa, you spoke about the hearing officer, you mentioned that we're going to be hiring a hearing officer to hear these cases. And I just wanted to hear a little more. I know that nothing's come forward to us yet. Is it going to be an attorney? Is it going, what's your vision for that? It's going to be a new position, correct, in the district?
Yeah, I'm going to defer to.
Thank you. So the intention here is to develop an RFP that would go out into the community. Heretofore, we have had the luxury of volunteer hearing officers throughout the community, but through this new process, we're adding more accountability and more structure, and rather than relying on volunteers, so that it's at a date certain, and that we have trained hearing officers that we're looking for consistency, et cetera. We'll be going out for an RFP. So the development of that RFP hasn't actually occurred yet, but it could be. I mean, the statute allows lawyers and non-lawyers, retired judges, et cetera. But we will make sure that the criteria is developed with a lot of input.
So just as a follow-up, our school police officers are very special people. They're people that love working with children. They're not your typical people that you would see in that role. So I would anticipate the same thing, that you're going to be looking for certain qualities where you're going to have someone who's sensitive and understanding. So I'll look forward to the RFP, but I know that they will be a very special person also. Thank you.
Mr. Shaw?
Thank you. On the hearing officer issue, can you clarify what the role of that hearing officer would be, and what authority they have? Because the superintendent would be making a recommendation, and I assume the hearing officer does not have the authority to not support that recommendation. So can you clarify what that role would be?
Yes, so the hearing officer's authority would be the same as it is currently right now under Chapter 120 of the Florida statutes. The hearing officer would issue findings of fact. And then they could also do the mitigation piece of it as well. They could issue a recommended order that had findings of fact as to what was proven on both sides of the case, and then issue credible mitigating circumstances if the student presented those as well. That would be the hearing officer's role. That order would then come to the board for the board's review as well, and superintendent's review prior to a vote for expulsion.
But it comes to us simply as a recommendation.
As a recommendation, yes.
Can you address, are there any issues that we need to be aware of, considering all of the issues with the Stoneman-Douglas law and the impact that has on expulsions?
The Stoneman-Douglas law does not specifically address expulsions other than through the threats, the issue of the threats that have to be documented, the threats. Other than that, I mean, we would be following the exact same process we're following now,
Right.
or would be recommending to follow.
So I have a question. So I'm on slide 12 with the key changes that shows how it flows through the process. So is the mitigating factors, it looks like the school board will not make any of those decisions in the future with respect to either zero tolerance or other offenses based on that schedule, because it says the hearing officers issues findings of fact, including credible mitigating factors. By the time it gets to us, that's all been taken into consideration, and we have no jurisdiction or no authority to consider mitigating factors at that point, because it's already gone from the hearing officer, and then it comes to the board with a recommendation from the superintendent. So are we not part of that process any longer?
No. What the hearing officer, what we're hoping to do with this is to streamline the process and allow the parents an opportunity to present all of their evidence, and for the board to have an entire record to review prior to the family coming forward and having a short few minutes to speak before the board. We'll have a hearing officer's order with a fully developed record that then you would have an opportunity to review and follow up with questions to the family if they chose to appear before you.
Okay, so if we don't agree with respect to the mitigating factors, where do we have the authority to change that?
The hearing officer just provides a recommended order. The board does not have to adopt that recommended order.
So the recommended order is to the school board and not to the superintendent?
Excuse me, I'm sorry. We really need to draw a bright line between the zero tolerance cases, which have a different legal standard for
Okay.
authority.
Right.
So I think that to, allay any confusion. So in the zero tolerance cases, by statute, any mitigating factors, such as the age of the child, and parenthetically, those mitigating factors, as we work through a new policy and for you as we go on, should be codified in policy so
Yes,
that they are clear and
absolutely.
consistent, and there's some defined criteria. But the statute allows for mitigation based on the age of the child, the facts and circumstances, in the authority of the superintendent for zero tolerance cases, those with weapons, those with threats, et cetera. On the non-zero tolerance cases, while the board has the authority to mitigate those expellable offenses, the new policy that's going to be recommended and being brought forward for further development, so you'll have a chance to have more input on it in the future, is designed to have those cases not be considered expulsions. Those students would be recommended for and placed in alternative ed based on their particular action and based on the district committee, administrative committee's recommendation, and after all of the review, appeal, internal communications, et cetera, with the parents. And then finally, if the parent were not satisfied with that recommended placement, that family would go to a 120 hearing, not the board, but a 120 hearing, and then after that hearing, it would come back to the board. So it's a different process, and it's actually going to be a different standard. So those cases, such as possession of drugs, fights, certain offenses along those nature, would not be considered expellable offenses under this new methodology. Does that make sense?
Oh, I think so. So,
Okay, so what is the board, so the
so
bottom
this whole
line is
process that's laid out here is only for zero tolerance?
the zero tolerance cases would be going to a hearing officer. The superintendent has the discretion by law to apply any mitigating factors, and then it would come to the board for your decision. Just like we have in, so I'm going to kind of make the analogy because it's like, so what's the board's role? Just like we have in employment cases where the recommendation is made, the appeal goes to a hearing officer, it comes back to the board. You can make a new finding of the facts weren't correctly found by the hearing officer, the conclusion of law was not properly applied. So you can make a new a new order. Okay, you don't have to accept the hearing officer's order, but that's the 120, the Florida Statute 120 process, administrative process.
Okay,
It's the same.
So I get that part. So I guess where I'm confused is a non-expellable offense that used to be the type that we would consider at an expulsion hearing, that's going to be brought to us as something else.
That would go through an administrative process. That process would go to an administrative review and placement in alternative ed or whatever the consequences are, but it would not be an expulsion.
So there are no mitigating factors in that case whatsoever that we're considering? Yes or no?
Not in the sense of, not in the context of this expulsion process. There would all the facts and circumstances will be considered by administration when they look at placing that student in an alternative ed setting. I mean, correct?
Yes,
That's what's
exactly.
expected. And I think that to really see how that's going to work in real time, we should come back with a policy development on that. This is conceptual at this point, so I can't give you all the nits, but that's the concept. There's going to be a bright line between expulsions with services that are based on zero tolerance cases, and then all other offenses, the code's going to have to be changed, right? So we're going to have to draw that bright line. All the other offenses would come through administration for placement at alternative ed. There would still be due process to the student. It just would not be heard by this board as we have been doing it before.
Okay, so I guess you come back to us with the other process that we're not talking about today, which is the non-expellable, those offenses. And we're also going to have somewhere where the mitigating factors are codified, like the other board members have already mentioned, so that
Yes,
so that we're sure that all children are being treated with equity.
correct.
Correct? Mrs. Andrews?
And this may tie in, I talked with Ms. Kimona about this. I'd like to see a flow chart on both sides of these, because as you're looking at them, they're totally different based on what you're talking about right now, Mr. Barbieri, and the different steps. And so this was something that she asked me to bring up at this meeting today, if this would be something that we would want to see, because it's kind of laid out here, but if we had the flow chart to show each piece, how it works, where it's going, and what's happening.
Yes.
I think that would be very easily to be used.
Dr. Robinson?
So, okay. I'm so glad we're here. Finally here. Finally. Like, finally here. Seriously, when I first got on this board, we expelled children to the street, right? So if you made a bad mistake, you went home, like possibly unsupervised, and got no educational services unless your parents could pay, right? So to get to the point that we're saying that we don't want to label children with expulsion because they made one bad mistake that's not like that level, God, like finally, like we're looking at kids and not the system. It's just awesome. So I have a number of questions, and I think some of what I just heard my colleagues questioning actually is the next workshop, not in my head. Because, so what we're now talking about is the things that would be deemed expellable. And the definition of expellable for Palm Beach County schools is changing, which I think is a marvelous thing. So, to follow up on Ms. Andrews' question about the expulsion committee, so I understand that this would be work, but can we look at having a student advocate that would rotate? So I'm going to make this up and say if it's a Latino child, that it would be a representative from a trained representative. I get people got to be trained, but from a Latino advocacy organization, so that there's somebody there who is there to look through the eyes of the child, so to speak, right? And that would require like a list of people based on demographics and yada yada. I'm making this up, but I'm asking you to consider how that might be done, and so that it's not just school district people looking at this. The other thing, in terms of this hearing officer, this doesn't sound like a full-time job to me. Okay.
No, not in any way. I'm
Okay.
sorry for jumping in, but it's not a job, it's not a position.
Okay.
It's exactly what we're doing right now, except for instead of people being volunteers, we're gonna
Right.
put out an RFP with some criteria and
Okay,
pay
gotcha.
them a stipend, not gonna be, $1 million, members of the public, but it's gonna be
Okay.
a pay, hourly, like the Value Adjustment Board, I think, has, paid hearing officers. I mean, it's a hearing officer position, and they should be compensated. And so we're
Okay.
just evolving we're formalizing
Okay.
our process.
Okay, so I'll play with my ideas with you about that later. And thank you for this flow chart. I love flow charts, right? I love them. They make sense to me. Now, this off the public record session, it still doesn't make sense to me that we would have it in this room, right? I mean, it just seems cumbersome to me to say, okay, everybody's got to leave the room and it can't be recorded, when it's easier for us to just go in the other room as we've been doing. But I really think that was it. You taught me some new words, though. What is a slung shot? Like, really? Seriously? And then, like, seriously, I had to look that up.
So
that
did
was
I.
good. Yeah, and then, what was the other one? A dirk. Yeah, a dirk. So you said that was in statute, right?
It's in statute, we all
Yeah,
looked it up.
because it sure is not relating to current events, right? So all this, which is on, I think maybe I have an old copy, but the definition of weapons, all this is from statute?
That's the statute verbatim,
Okay, including plastic knife.
yes.
That's
It's
in the
excluded.
statute.
It's excluded. If you look at it, it says.
Oh, I'm sorry.
Yes.
Oh, okay, thank you. Because I was going, really, we're just like really going overboard. Okay. Like other deadly weapon except a firearm, which is categorized. Okay, all right. Thank you. I caught on. I really think that is it for my questions on this. Thank you.
Mr. Shaw, then Mrs. Andrews.
A question on the superintendent's mitigation issue, because this has sometimes been difficult for the board. If there's a student that's facing expulsion based upon a zero tolerance offense, and they go through this process, and the superintendent still has a recommendation that, move forward with that, does the board have the right then to say, well, we don't care, even though it went through this process, we believe because the parent said something to us in a meeting that's now mitigation, and we can change that. Do we have the authority for the mitigation on zero offense, or is that the superintendent's role?
So the law specifically states that zero tolerance policies must require students found to have committed one of the following offenses. That must require expulsion, means that and then the second portion of the statute only delegates the authority to the superintendent, means that unless the superintendent makes a recommendation to the board that the requirement be modified because the statute requires it, then unfortunately, yes, the board's hands would be tied.
Mrs. Andrews.
Thank you. I love all of this, but for where the key changes flow chart, I'm talking about a different kind of flow chart. You all do understand we're talking about two different ones, so I'm looking at a different type flow chart. And when you give me something, I always want more. Can you think about having some of those hearings in the Glades region, and not just always here, that everybody always has to come to this building? Our children come from everywhere, and the parents many times have difficulty making it over here. So if you could put that on your sheet, that we need to go to people sometimes, especially when they're having difficulty with their children or other things in their lives, to give them every opportunity to advocate for their children. We need to get out of here and meet them halfway. Thank you.
Any other questions? Dr. Robinson?
So I just need to follow up and make sure that I'm following. So with the issue of mitigation, so then the board would say, we believe these to be mitigating circumstances as a general rule across the board. And it would be up to the superintendent to apply them with consistency. And then, and let's pretend not, like, let's pretend there's a case that there was mitigating circumstance 1, but he felt that there was something over here that countered that, so he would still recommend it for a whole year or whatever. That's all on him. Okay. And then the other thing I want to say is, so I had requested a whole bunch of information, and I appreciate you sharing that. Of course, I haven't had time to dig into it, but, and you know I will, right? So, but it, just glancing at it, it looks like everyone listed got expelled on that chart. No. So, so I would request that on a go-forward basis, that we just keep that, like, whoever goes to this expulsion committee, that there's a report, maybe a quarterly report on who went and what the outcomes were, because we're going to see fewer cases. And I think it's important. One of the things, as I shared with our general counsel earlier, is even though that closed session seems to be a little bit chaotic sometimes, one thing that it has done, though, is applied some humanity to these circumstances, which I think is good for us to see. And so I just want to make sure that we continue to see what's happening, so we don't think that everything is just lovely and rosy just because there's only been 3 expulsions. So I need, thank you.
Okay.
I'm sorry to go back to this, but I'm still a little confused. I'm looking at the chart again on slide 12. So what is the purpose, if this is a zero tolerance offense, what is the purpose of the parent sitting before the school board in a closed session when we have absolutely no authority at that point, because the superintendent's the only one that can mitigate, and he's making a recommendation that they be expelled? I mean, what's the purpose of us sitting in a closed room with the parents
So
to
if
have them plead with us to change that?
So if I may answer the question, so the closed room, if we continue to do it in that methodology to afford the student confidentiality, any member of the public, and particularly an affected member, has the right to speak in front of the board. So they can still come and speak. They will know coming into it with this changed policy what the board's authority is in that circumstance.
Which is what? What is
To
it?
rule on the superintendent's recommendation, and the only other thing that you can do is look at the recommended order and find a different finding of that the administrative law judge, the hearing officer, applied an incorrect standard, found the wrong fact, applied the incorrect standard of law. Those are the same things you can always do with a recommended order. This is following the Administrative Procedure Act. But what you can't do is apply the discretion of the superintendent to say, it was the first time, this is an A student, it was, a tragedy, we're not going to. Those mitigating circumstances is not for the board to apply within discretion. It would be looking at the recommended order, applying a different, finding of fact if the judge was incorrect, and listening to any affected individual who comes before the board when action is taken. So that would be your role.
So in the past, we've not had the authority, and they're told when they come in that the board does not have authority to rehear the facts or to reconsider facts, and we're not going to talk about the facts. But in this case, you're telling us that we can go into the hearing officer's whole report and say, we don't agree with the facts. The parent is now here telling us something different. So now we're going to hear the whole thing over again? We're going to have all the facts disputed by the parents?
No. No, you would not. Just like an administrative proceeding action, similar to employment law, we've terminated and we've moved on the recommendation of the superintendent to terminate an employee.
Yeah.
The employee takes an appeal. It goes to a hearing officer. It happens to be an administrative law judge. We can use the administrative law judge process, but we are also allowed to hire these hearing officers. So it goes before the hearing officer for findings of fact and conclusions of law and making a recommended order. It comes back to this board for final approval. Same exact circumstance, same exact situation. Never, when we have an employment appeal and an exceptions hearing, do we hear the whole trial over again. We hear an argument of the summation of the record. So it would be the same type of thing. That would be the same setting.
Okay, I guess I'll wait for the policy to come forward, and we'll see what we're going to do with that one. Dr. Robinson and then Mr. Shaw.
May I just clarify, though, before that, may I?
Sure.
The difference in the new process and the old process is that we have had mitigation not heard by the hearing officer and recommended, but heard directly by the board. So the mitigating circumstances, although unfortunately we did not codify, it's the first offense, this is a child who didn't understand, this was somebody who's an A student, this is a child who's rehabilitated themselves, et cetera, those mitigating circumstances that we have heard by the parent, advocate, et cetera, in front of the board was a piece of that hearing that we have undertaken ourselves. That's the difference.
Okay, so, I understand I'm talking 3 times in one item here, so the parents are going to be told when they walk in the room that the board has absolutely no authority here because the facts have been laid out. Unless we want to dispute that the facts are not the facts, we have no authority. So the parents are going to be told that the board really has no authority. You can talk to them all you want, but they can't do anything here, right?
We are no longer having mitigation hearings because that mitigation piece is part of the original case. It is
I get it, but I just don't understand having the closed session then. I mean, these parents are going to come
only
in
to
expecting us to do
afford.
something.
No, they aren't expecting you to do anything different than rule on the matter, just like any other board item.
But we have no authority in a zero tolerance case to say no to the superintendent, do we?
The only reason you're having a closed door, if we continue with the closed door under the indicia of making sure that it's an appropriate closed-door session, is to afford the student confidentiality. That's the only reason we're doing a closed door. It's not some new hearing.
Okay. All right. I think there was several hands that went up, but Dr. Robinson, Ms. Brill, I don't remember who was who, but who was first? Mr. Shaw?
So the other added benefit, though, for me would be maybe we might want to change our list of mitigating circumstances that we provide to the superintendent as guidance. But we could still vote his recommendation for expulsion up or down. Yes. I mean, okay. And then the other thing is the chart is only expulsions. And so my request is that it's everybody who was recommended for expulsion, because I want to see if what they say is true, right? That demographically is different if, recommended makes it to expulsion or gets turned back. And then on a go-forward basis, if we continue to collect that data, report that to the board on a regular basis. Okay. Thank you.
Mr. Shaw, then Ms. Brill.
Part of where we're here today because of what we as a board requested. And, one of the things that we heard in all these hearings is always the question, well, the parent says they never heard about this. They never had a chance to find out anything. This ensures that there are multiple layers where parents have the opportunity to hear, to be heard, and the student has multiple opportunities to be heard. We have parents who, if they happen to walk in with an attorney, sometimes we react differently because there's an attorney sitting in the room when there's a parent who doesn't come in with an attorney. There are times when we find out after we've had the hearing and you talk with the principal of the school that there were many, many other factors that should have been considered. I think the change that we just made now ensures that all of those layers are in place. So quite honestly, when it comes to us as a board, everything that we were asking for has been done. So I think that's when it's really our decision now is either we vote yes on the expulsion or no. We shouldn't be in a position of rehearing these things at all. And I think this takes that piece out. And, my understanding has always been the only reason we have this closed session with parents is really for the confidentiality of a student. There's no requirement for that. They could be saying the same thing in an open meeting. So I think that this is a good change from the policy if we enforce the policy the way that it's being recommended.
Ms. Brill.
Thank you. So I'm going to return to what Mr. Barbieri said and Mr. Shaw, because I was listening very carefully to the words of our general counsel. And I understand what Mr. Barbieri was saying. It's very difficult when the families come forward, and I think we can do something. We're only going to be hearing the zero tolerance cases. And Ms. Rico, twice you said, if the board decides to continue with the closed-door session. So maybe in our policy, it becomes that, if perhaps you offer to those families of students who are being expelled, if you would like to speak in a confidential environment with the board, you may, but they're not going to be able to change anything that's going on. But that if is what's throwing me, because it seems like we routinely, when we're going to vote on expulsions, have those meetings. And if we have the latitude to not have them unless a parent requests it, I'd much rather do that.
So, if I might, rather than try to talk about speculative processes, this presentation today was to address our current state and then where we're going with a further recommendation. If you would allow me and the team to develop the scenario with the step-by-steps, what the lines of demarcation would be, when you would be in a closed door, what the indicia of that closed door would be, so that we're in the confines of the law, which is very important, of course, to have a closed door session. I would appreciate that if we could come back with those details, and we will provide the clear demarcation of what the board's authority is, superintendent's discretion, and I guess a mock-up of the policy, criteria, language, those kinds of things, rather than speculated here at this stage.
All right, I just have one question that you consider when you're doing all that. And on slide 13, it says, zero tolerance policies must require students found to have committed one of the following offenses to be expelled. So you indicated that we had the opportunity to not accept the superintendent's recommendation and we could say we don't want the student expelled, but currently the law says we don't have that authority. So there is no point.
So no
point in having a closed session if there's no possible way that we can vote no on the superintendent's recommendation for expulsion. So keep that in mind. I don't expect you to address it today, but I just don't see any reason to offer the parents this hope that the board can do something if they're come and talk to us, when there's absolutely no way, if it's a zero tolerance offense, that the board has any authority other than to expel, unless the superintendent finds some reason to give us a recommendation not expel because of mitigation. But if once he comes forward and says it's got to be expelled, we have no authority. So I just don't want the parents walking into a room with any kind of hope that there's anything the board can do, because at that point we have absolutely no authority to do anything other than to accept the superintendent's recommendation on expulsion. If I read the law correctly, I mean, just consider that when you're looking at how this is supposed to work. All right? All right. Any other questions? If not, we'll go ahead, Dr. Robinson.
No, I'm just going to correct something I said. I'm not even going to dig into that. So the chart, so I do see now that the last column tells me what actually ended up happening, and the one that says all expulsion, those were all recommendations for expulsion. So can I get it in an Excel so I can sort it?
Yes, we'll give it in an Excel, and there's some additional information we'll be adding to that.
Great, thank you.
Okay. Superintendent.
Thank you, team. At this time, I'll turn it over to Chief Academic Officer Glenda Sheffield for our workshop on alternative education.